everyone. Welcome back to Immigration Insights, the immigration podcast and videocast of Greenberg Traurig. I'm your host, Kate Kalmykov, co-chair of the Global Immigration and Compliance Group. We have a fascinating episode today dealing with common employment law questions, problem situations that may come up, audits, and issues that employers really need to be aware of. And I'm thrilled to introduce two of my colleagues from the New Jersey office that are both in the Labor and Employment Group here at GT, Feher and Raquel. So Chris, can you introduce yourself?
Sure, I'd be happy to. First of all, thanks for having us on, Kate. We're happy to join you. So I am an employment lawyer. I've been a shareholder with Greenberg Traurig since 2011, and I am the chair of the Labor and Employment Group here in the New Jersey office.
Raquel?
Thanks, Kate. I am a shareholder in the employment group as well. I've been with GT since 2015, so almost 10 years. And we help, as you said, employers with sort of the whole gamut from beginning to end of the employment relationship and everything in between.
Excellent. So let's get right to it. And let's talk about employee hiring and considerations in employee hiring. So oftentimes we hear about wages, classifications, job titles. I know in immigration, we deal with that a lot. And one of the concerns that the Department of Labor always has in immigration applications is making sure that we're not giving preference to foreign workers by underpaying them and displacing US workers. But tell us a little bit about how you deal with this issue in the employment law context. Chris, why don't we start with you?
Sure. It's actually a little bit in tension with the issue that you deal with on the immigration side, because from the general employment side, the issue is typically one about whether U.S. workers have been underpaid or if there's been a failure to pay them overtime or to properly record all of their hours worked. So Raquel and I are frequently called upon to help employers with kind of reviewing their pay structures and their processes to make sure that they have people properly classified as exempt or non-exempt from overtime, meaning whether they are not eligible for overtime compensation, and making sure that people are paid properly, that their timekeeping systems are correct so that everybody gets paid for their hours worked, plus any overtime that they're eligible for. And one of the things that we also are involved in is defending employers if they get sued with respect to pay issues. And a lot of times those come up in class actions where all of the employees together or all of the employees in a certain job title may claim to have been denied overtime or not properly paid. And then they file a class action lawsuit. And those can obviously be big stakes for employers. So we try to avoid them, but it is one of the things that we get involved in defending. And I know from the immigration side, as you said, it's a little bit, there's a little bit of tension with that, because from the immigration side, there's always a concern about making sure that those foreign workers are not paid less than the U.S. employees.
In fact, we also commonly deal with perhaps we have somebody who hasn't been selected in the H-1B cap. They really want to work for a company, their OPT is running out, they want to do unpaid internships. And we have to advise them, because this is an employment law issue that we commonly bring you in on, because they're wanting to do an internship, but it's actually constructive work. So what sort of issues are implicated there, Raquel?
So we have clients that come to us all the time and say, we've got somebody who's going to be an unpaid intern, and they start to describe a structure to us where it's very clear that the person is in fact going to be an employee. And under the law, there are sort of tests and elements that have to be satisfied for somebody to properly be classified as an intern, and it's really stringent. The scenarios where somebody actually would meet the definition of an intern such that they could work essentially for free are very limited. So a lot of times we are, having to gently redirect the intention and sort of help our client restructure a little bit what they were thinking for this person, because again, it's extremely narrow circumstances where someone's actually going to qualify as an unpaid intern. Sometimes, employers do it and come to us after the fact and say, I think that we might have made a boo-boo there. We had this person who was working unpaid and we thought that they met the definition of an intern, but they're now raising some concern and saying that they should have been paid. And so we often will help on the back end too if they get themselves into that kind of a situation. So yeah, we see that a lot. And I would, say that the sort of cautionary tale is before you classify somebody as an unpaid intern, really make sure that they hit those standards, because if the relationship goes downhill, it's sort of an easy thing for somebody to raise later on and make some trouble on the way out.
Let's talk about the relationship going downhill. How common is it that an employer gets audited because the relationship goes downhill? Chris?
I would say not that common for that reason, right? We have audits and we don't always know why an employer is audited. So a lot of times an employer will get a notice that it's being audited, and that could be by the Department of Labor, it could be by immigration, it can be by different agencies. And we're not always told, the employer's not always told why. What triggered it. Sometimes it's a disgruntled employee. Sometimes it's random. Sometimes it's a series of complaints that might be, for example, about a wage issue that trigger the agency to say, you know what, let us come over and take a look at your books. And of course, when they do that, that becomes it can be a big cost for employers. It can create all kinds of exposure, right? Because the audit may have been triggered by an employee or a series of employees complaining, I wasn't paid fairly, I didn't receive equal pay as compared to somebody else who's doing the same kind of work as me. But when they come in, they're going to want to look at your I-9s, and Kate, obviously that's something where I would circle back to you and say, hey, we need an audit, we need it done, a self-audit, we need it done quickly so that we can address any I-9 issues we have, and you might want to speak to that for a sec. But they're also going to want to look at all of your payroll records. They might want to take a walk around your facility and see if there are, safety issues. They might want to look at your job descriptions and try to assess whether people are properly classified as exempt or non-exempt. So there are a whole variety of issues that can come out of an audit, whether it's triggered by a disgruntled employee and a relationship going downhill or not.
Tell us a little bit in more detail what employers deal with in these audits, and are they subject to sanction? Are they dealing with penalties? Is there criminal liability?
It can be any of those. It depends a little bit on which agency is looking and what exactly they decide to look for. A lot of times they come in with a very, very broad scope. I've had agencies come in and say, we want all of your payroll records for all of your employees going back 5 years. We want all of your I-9 records. We want, we want personnel records. They ask for a lot of different things. And sometimes employers don't know that they can challenge those things. And, when they hire us, the first thing we typically do is reach out to the agency and say, look, can you give us an idea what you're really looking for, what your concerns really are, and maybe we can find a way to narrow this. This is very burdensome for the employer. Of course, we want to cooperate, but perhaps you don't need all of this. Perhaps we can give you a random sampling of payroll records, or do you really need personnel files? There's a lot of confidential information in there. So we usually try to narrow the scope. But sometimes the agencies, they can find things that they weren't even looking for. So as I said, if they come in with a concern about pay, and that's what they're investigating, but they ask to look at your I-9 files for all of your employees, they may very well find that you haven't been keeping I-9s for all of your employees, or you didn't do them correctly in the first place, or, you have missing ones or errors. I mean, from my experience, and, I certainly defer to you on this, almost every employer has some mistakes in their I-9s. And so you can often be looking at civil penalties. You can be looking at having to pay back pay or even liquidated damages to employees for payroll violations. There's really penalties to the agencies. There's really a wide gamut of potential exposure.
You're absolutely right. And in the I-9 context, we work with you hand in hand because absolutely the agencies talk to each other. And once they find something wrong in one area, they're more than happy to come in and audit something else. And with the I-9s, employers really give little attention to it. They look at it as a one-page form. This is easy. It's no big deal. I have never done an audit where an employer had 100% correct I-9s, even when they're on E-Verify. And, the agency finds this as a really easy way to generate revenue for themselves and, to show that they're earning their keep, so to say. And the I-9s, they're not just for foreigners. And I think that's a big misconception about employers, by employers. They're for everybody. And US hires have to complete them, and they have to complete them properly. And if you may have somebody who's a US citizen and they check the box that they're temporarily authorized to work, and then you get pinged because it seems like they're working without authorization.
But Kate, one of the issues that we do have for our employers, we have a lot of employers who have employees all around the country. And as they have spread out, they don't always have offices. They have remote employees. So how do they handle I-9s and reviewing documents and things for those employees who are scattered around the country or even at times, around the world?
That's a great question. So during COVID, the government introduced flexibilities in this area where it allowed for remote verification. And when the COVID flexibilities expired, the government said, well, listen, there's a lot of value in this, but we want people to sign up for E-Verify, which is the government's free online electronic verification form. The employer enters into an MOU with ICE, Immigration and Customs Enforcement, agreeing to be audited whenever they feel like being audited by ICE. But in return, they get advantages. So one of the advantages by joining E-Verify is they can take advantage of remote verification. They note that they're an E-Verify employer on the I-9, and they can do the I-9 remotely. Now, if an employer is not a member of E-Verify and they have employees scattered around the country, depending on the state, we have to either hire an agent or an attorney to assist them in doing it. But certain states have quirky rules, like California. So it's very important to do a state-by-state analysis and make sure you're doing it correctly. Raquel, I know you wanted to jump in here.
I was just going to piggyback on something that was said a little while ago. But there are plenty of times where a client will come to us with some issue, to your point, Kate, about the I-9 seeming like not a huge deal. It's a one-page form. What's the big issue? Sometimes a client will come to us with some issue about, whether an employee was or wasn't paid minimum wage, whether the employee was or wasn't paid overtime that they were owed. And it seems pretty small, and the, client isn't isn't seeming terribly concerned about it or taking it super seriously. And, these DOL audits are one of the things that we say to them, again, sort of a cautionary tale, like, this seems like not a huge issue, and it seems like a one-off and just a small thing we can easily rectify with one employee. But you've probably got other people that are misclassified. You've probably got other people, who perhaps haven't been paid properly. And as we said, all it takes is sort of one disgruntled person to, help an agency open up a can of worms, and then it just snowballs from there. So it's a lot of it is about being, if you're going to do it right, a lot of it is about being proactive and sort of agreeing to invest the time and the legal resources in allowing us, as Chris mentioned, to come in and do a proactive internal self-audit before the agency comes in and finds problems. Or allowing us to look at your employees and their classifications and analyze whether they're classified properly by looking at their job descriptions and talking to their managers and try to help them head off these issues. So a lot of times it is a small thing seemingly that kicks off a much bigger problem. And, one of the things we do is try to help our clients avoid those issues in the first place.
That's a great point. And we do the same thing with I-9 audits. We encourage employers to do them routinely, to do annual trainings. And before they join E-Verify, 100% they should audit, because you're letting the government in, you're agreeing to be audited. So we need to, even though you're going to get a safe harbor later on, we want to walk into that situation having been completely compliant. Now, I want to ask the both of you, in the context of mergers and acquisitions, what's your role? How do the employment lawyers get involved? Chris?
Sure. So a couple of ways. One way is that we'll be asked sometimes to run due diligence. So we will be asked to look at all of their kind of employment infrastructure, their policies, perhaps, their benefit plans and programs, their job descriptions, and their I-9s maybe. It's all about making sure that the company being acquired sort of has things in place. We will look at litigations that are pending, as well as like any potential disputes that might lead to litigation and the costs that might be associated with those, so that the acquiring company can have some sense of what the employment related exposure is. So we'll do diligence review and, give sort of a summary of our findings for the parties. And then we also get involved because a lot of times, of course, in that context, the acquiring company is taking on at least some key employees from the company that they're acquiring, if not the entire workforce. And so in that context, we might be asked, first of all, to handle communications, to handle executive employment agreements or restrictive covenant agreements for those people who are coming on. And if the acquiring company is not taking on all of the employees, there might be a WARN Act issue where employees who are being separated in a mass layoff need to be notified in advance, and certain procedures need to be followed, which can result in massive exposure if they're not properly followed. So we touch that at a lot of different points.
And we also, no one thinks about the immigration lawyers when they're doing a merger and acquisition, but we also get involved because we see a lot of times that the company just agrees to assume the I-9s of whoever they're acquiring. And they may be assuming a lot of liability, and they're not correcting them ahead of time. They're not agreeing that they'll re-I-9 the workforce. And we've found that that is a huge, huge issue. And, sometimes it comes up much later. You may have acquired and, they just throw the I-9s in the pile, and then you get audited and people are out of status. They haven't updated their documents. They may have even acquired a company where they haven't even completed I-9s, which is a huge no-no for ICE.
Yeah. And, when I'm in this process, I typically will advise my clients, if you're thinking about taking the I-9s of the acquired company, let us audit them first and send that to your group and have you guys do, as, especially when we're not dealing with a workforce of thousands and thousands of employees. But, if possible, let us take a look at the I-9s first and make sure that they are in decent shape, because it is always concerning to think about acquiring a company and not knowing, just taking those on and not knowing what you're getting into.
Absolutely. It could be hundreds and thousands of dollars in penalties.
What about, Kate, in the context of, if the acquired company has non-immigrant workers in particular, or even workers who are in the green card process? That's an area too, where if I find out, I would ask about that in the due diligence process and reach out to you guys to talk about kind of what the impact is on them.
Absolutely. So we may need to do amendment filings. We may need to, let them know there's a new employer. It's going to depend on what the acquisition looks like, and there's a concept in immigration law that applies to many filings, both in the green card categories and in the non-immigrant worker categories, of successor in interest. The successor in interest steps into the shoes of the previous employer, but it doesn't always work. And a new employer may have their own structure. They may have different wage classifications. They may have different wages. They may move the employees to different locations. And that many times may require an amendment filing, especially depending on the type of visa. There's certain visa types, work visa types, such as the H-1B, that are very specific in their requirements. If you leave the MSA, if your position changes, if it's a material change, you have to do a new filing, both with the DOL and USCIS. So let's talk a little bit about performance management. I know that we often deal with corporate clients where they're dealing with very difficult employees. Perhaps they want to terminate them. And there's implications both on the immigration side and, of course, on the employment law side. So, Raquel, what are your recommendations typically in performance management?
Yeah. This is an area where we have done a lot of work recently. I would say a lot of training, a lot of coaching. I feel like a lot of clients have sort of gotten the message that, their managers, perhaps are in need of a little bit of guidance in this area. And I think it's been sort of a hot topic recently of how do we deal with someone who we kind of know isn't really long for this role, maybe isn't long for this company, but we don't think that we've necessarily taken the proper steps to position ourselves correctly to part ways at this point. So a lot of times we'll get the call sort of at that point, maybe like the 75% mark where they kind of say, we know we need to do something here, but we haven't really set ourselves up for success. Maybe our performance appraisals haven't really been accurate. Maybe the feedback that should have been given to this person hasn't really been given the way it ideally would have. Maybe we've just promoted them, even worse, right? We've sent mixed messages about how this person is doing, and now all of a sudden we want to kind of pull the plug, and it feels a little bit confusing. So we do a lot of this in the counseling space. And one of the things that we try to do from the start, if clients will have us, is come in to train on this topic, because this is really an issue for managers and supervisors primarily. They're the sort of front lines in making sure that when you are at the unfortunate point of feeling like you need to separate with someone, that the right things have happened to date to be able to do that. Because this is a hot point of legal exposure, right? Most of our cases come out of some kind of discipline or termination scenario. So like sort of key things to think about when you're, setting up a separation is, as I said, performance appraisals, right? What have you communicated to this employee in the last couple of years about their performance? If we're hearing on the phone, this person has been a nightmare for years, and then we're looking at 3 years of glowing performance reviews that have sent the message to this person that they're in fact doing a great job. That's not good evidence in a lawsuit, right? When we want to say that our legitimate non-discriminatory reason for separation was bad performance, and we've got, hard evidence that wasn't the case. And sometimes it's not intentional, right? People just don't like to, human nature, nobody likes an uncomfortable conversation. So a lot of times it's training managers to have the uncomfortable conversation, write the uncomfortable critical feedback, because it doesn't benefit the company or the employee to, hear things that aren't reflective of the reality. Documentation is another issue, right? When do we write people up? When is it overkill? When are we looking like we're papering the file and being nitpicky and sort of targeting someone versus picking the right moments and documenting in the right way? So a lot of the time we, train employers on that, right? Documenting, but doing it the correct way. What to say, what not to say, where to keep that documentation, what to share with the employee. Does the employer have a progressive discipline policy that needs to be followed, such that we have to start with a written warning and then escalate to, to follow those steps? So there's a lot that goes into that, but it's sort of the main overarching theme is that when it comes time to separate with an employee, that you sort of taken the steps leading up to that moment that will best position you to defend the decision later on if you're accused of having done it for the wrong reasons.
Yeah, and if I could just follow up on that, Kate, to Raquel's point, documentation is a big issue. Understanding the other factors that you have to consider when you're performance managing or terminating an employee. For example, has that person recently taken a leave of absence? Has that person been a whistleblower? Has that person, are they in protected categories that sort of increase the risk, and figuring out how to handle those. And one of the things that employers do is they promote people who are good at their jobs. right? That's if you're good at, computer work, you might get promoted to computer, some kind of network systems manager. You can tell I'm not one of those people who's good at computers. But you get promoted because you're good at the underlying job, not necessarily because you have managerial skills. And a mistake that a lot of employers make is failing to account for that, failing to train those people who are good at the underlying work on how to now also manage people and what they need to know. A lot of employers will do basic anti-harassment training and kind of call it a day. But what Raquel's talking about, we do a lot of programs where we actually will sort of train on the nitty-gritty. How do you interview somebody? How do you interview somebody and avoid the roughly 7,000 minefields that exist with respect to asking the wrong kinds of questions that aren't permissible? How do you document, as Raquel said, when somebody has performance issues and have those hard conversations? So those are some of the things that employers don't always train their managers to deal with, and that can come back to bite them later.
And there's probably state to state considerations here too, right? I know, for
Absolutely.
example, we deal with wage transparency laws a lot in the immigration context, but probably in what you're talking about, there's a lot more to take into account state by state.
Absolutely. There are federal laws and state by state laws. So in almost everything that you do in employment, you are looking at federal and state, and sometimes also local laws. So there are jurisdictions where, what you can ask about, for example, somebody's criminal history. That there are federal restrictions, there are state by state restrictions, and some cities have their own restrictions on that as well. So, kind of knowing where the minefields are is terribly important in employment, and something that not enough employers proactively train their managers on.
And I think that's one of the things that we really take seriously here at GT. And I know probably when you're representing employers, you're working with colleagues, employment law colleagues in other offices in other states to advise on this.
Absolutely. Yeah, no, that's one of the big things that I think is a huge advantage of GT, is that network that we have, right? If I have a California employment issue, in theory, I can research that issue and advise a client. But we have a huge employment bench in California, and California is a very unique jurisdiction. They have a lot of laws. They have local laws and rules, city by city. And it's really good to have somebody who knows how things are actually applied on the ground. So that is a huge advantage for us. And we also are litigating around the country. So Raquel and I have cases in New York, New Jersey, Pennsylvania, California, where we're sort of partnering with people. I have one in, I think, South Dakota. Is that right? I mix up my Dakotas. And because we have people around the firm who are admitted in those jurisdictions, we're able to, partner with them, handle litigations, but also have the boots on the ground and the local knowledge that we need to do that well.
Yeah,
Absolutely.
and just to jump in with another example there, there, to your point, Chris, there are sometimes really specific local considerations with employee separation. So I was dealing with an issue with a Chicago employee not too long ago. And I ended up emailing somebody in our Chicago office and saying, hey, do you have the list of Illinois statutes that should be identified in the release? And they said, yes, happy to help with that. But also, where in Illinois is this person? Are they in Chicago proper? Are they in a suburb? Because there was some new, I think it was a local ordinance or perhaps a regulation that there needed to be some very new and specific language input into the separation agreement in order to make it enforceable, where the person represented that they, something very specific and unique that we would not have had in our standard template for New York or New Jersey, for example. So again, just a moment where I was incredibly grateful for the GT network, because not only did I get what I had asked for, but she spotted and helped ensure that agreement was done correctly.
Yes. And I think it also is super fascinating because, just from a geeky point of view, immigration law, employment law, it's very dynamic. It changes all the time. And we're dealing with people one-on-one. We're dealing with employers. We're dealing with employees. There's a lot to keep track of, but I think it also keeps us on our toes. And I know for me, it's the super interesting part of the job. Now let's wrap up with more terminations, but this time let's not talk about performance-based. So let's talk about what happens when an employer has to lay people off. They're doing a reduction in force. We saw this a lot during COVID. People sort of went into crisis mode and had to shrink operations, then maybe, you know, they went on a hiring spree afterwards. But, you know, things tend to be cyclical based on industries, and sometimes they contract. So what are important considerations to keep in mind for that, Chris?
There are a lot of them. Some of the things you need to think about are, as I mentioned earlier, Warren Act notification and state comparison laws. That is implicated if you are closing down a facility or if you are having a mass layoff and if a certain number of people are impacted. And I say certain number because it differs under federal law versus state laws, which are sometimes broader than the federal laws. So if you're having a plant closing or a layoff where you're impacting, you know, I would say anytime you're impacting more than 30 people, you should at least check and find out whether you're going to have any kind of notification requirement. And anytime you're shutting down a facility. And those are important because the exposure can be really significant. Those laws require advance notice, usually 60 or 90 days, depending on the law, to those employees, where you're keeping them on payroll for that period of time. And if you fail to give that advance notice, then you can be liable not just for that amount of wages to each employee who didn't receive these sufficient notice, but also potentially other damages. And there are notifications to state and city government that often go along with that. We also think about disparate impact analysis. So, for example, you know, employers pay a lot of attention to diversity and to recruiting diverse workforces, and there's a lot of attention and focus on that on the front end because of all of the good things associated with that, the benefits it brings to us, as well as just sort of the intrinsic benefits of having a diverse workforce. But when you're on the tail end and you're doing layoffs, you also have to analyze who are we laying off and how does that compare to our diversity statistics for the workforce, who's being laid off, who's being left behind. So for example, if you have 10 employees on a team and you know, 4 of them are female and 2 of them are African American and 1 is Asian, when you need to lay off half of that team, are you laying off all of the female and diverse employees, or are you laying people off in a manner that's proportionate to the workforce? And a lot of times employers will say, well, doesn't that mean you're telling me to make a decision based on race or based on gender? And that's not the answer. You're making a decision based on legitimate and objective factors, such as what their performance review ratings have been, what the you know, anticipated role of the job is going to be going forward after the layoff, things like that. But we will push you and say you need to look at those criteria, make sure those are legitimate and appropriate. And if your proposed layoffs would disparately impact women, people of color, any protected group, then look at those decisions hard, challenge them, make sure that they've been carefully analyzed, so that you're making the right decisions, and also so that those decisions are defensible if they're challenged later on. Raquel, anything you want to add?
Sure. So when you get past all of that and you are at the point where you are preparing your separation agreements, a lot of times with a reduction in force, employers do offer some severance pay. So a consideration and something to be concerned with there is the timing of the period that the person has to review the agreement and consider whether to sign it. So for an employee age 40 or older, if you're laying off one person under federal law and you're having them waive age claims, which is part of sort of a standard release, they get 21 days to consider whether to sign the agreement and 7 days to consider whether they want to revoke their acceptance of the agreement, basically have a change of heart. In a reduction in force scenario where there are more people being laid off as part of sort of one program and being offered a separation package as part of that, that period extends to 45 days. Again, seems easy enough, 21 days to 45 days, 7-day revocation, but a lot of employers forget this, and they leave that 21-day period in. Does it always become an issue? No, but it can. So we want to, make sure that we ideally get involved in helping employers prepare their separation agreements, especially in a reduction in force context, and make sure that everything is kind of locked up, that each state, especially for multi-state layoff, their employees here, there, and everywhere that each individual agreement is tailored to state law. And again, that might involve consulting with colleagues, across borders, but that's another thing to kind of keep in mind, as well as age disclosures. So in a reduction in force scenario, again, where you have sort of like a group layoff and everybody's being terminated pursuant to this one sort of program and offered separation pay as part of that, employees over the age of 40 are entitled to receive what we call age disclosures under a federal age discrimination law. And that involves it goes to the analysis that Chris was referencing initially about making sure that your decisions don't disproportionately impact a particular group. In this case, it's age particular, but you essentially create a chart which identifies folks who were impacted for the reduction in force, folks who were not impacted, and their ages. Nobody's identified by name, but you sort of break it down by category, usually the business unit or the work unit that each person has been selected from, and you see who stayed, who went, and their age. And that's really important because if you don't provide that, along with the 45-day adjustment, it can invalidate your release under federal age discrimination laws. So that's another thing that if your employees go ahead and visit with an attorney to have a review of their separation agreement done and say, hey, should I sign this? Is this a good deal? Does everything look like it's locked up tight? The absence of age disclosures is sort of a glaring red flag, and the attorney will, undoubtedly raise that with the company.
One other thing to consider here is if somebody's a foreign worker, if somebody has, employment authorization because they're on a work visa through the company, perhaps they're in a green card process, the employer has an active obligation also on certain visa types to notify both the Department of Labor and the USCIS, the immigration agency, that they're terminating employment. And then the employee has a certain grace period to leave the country, either find new employment, change to a different status, or leave. And likewise, depending on where they are in the green card process and the green card process that they have embarked on, they may lose that. And so this is something that we find employees get very emotional and upset about in these sort of contexts. And they often come, to the employer, ask them, listen, I know you're terminating, but on the books, can you keep me on so I can get my green card and then you can terminate me? And of course, if they're not working for the company, that, can be considered fraud, and it could impact both their ability to get status in the future in the US, but certainly also the company. So that's something to be very, very cognizant of. And many times, they will refer back to an email, maybe where the employer offered them status, where they promised to sponsor them, an offer letter. In certain cases, we have employees that are, working pursuant to a contract. They're not at will. So this is something also very important to speak to an attorney about. Okay, ladies. Well, I thank you so much for coming on the video podcast today. It's the first video cast for GT, and I think we are doing a great job of showcasing both the breadth of our practice, but also our women attorneys. So I thank you for that. And I look forward to having you back to delve into these issues in more depth in the future.
Thank you. Thank you for having us. It was fun.